The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council and to those watching on our YouTube Supreme Court Live channel. At this time, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 o'clock docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Wednesday, September 15th, 2021 consists of one case. Appeal number 121447, Catherine Roll et al. Versus Laura Howard, Department of Aging and Disability Services et al. Sedgwick County, briefs both sides. This argument is scheduled for 20 minutes by each party. The appellant has reserved 4 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
David Calvert for Catherine Roll, ready for argument.
Steve Kerwick of Wichita for the petitioner and appellant Catherine Roll through her court-appointed guardians present and ready for argument.
May it please the court, Arthur Chalmers of the Kansas Attorney General's Office for Laura Howard and Mike Dixon, present and ready for argument.
Thank you, counsel. I do want to note that Justice Melissa Standridge is recused from hearing this appeal. We're very honored to have Judge Tom Malone, who serves on the Kansas Court of Appeals, sitting with us today for this hearing. Judge Malone has been a judge of the Court of Appeals since 2003. Before that, serving on the bench in Sedgwick County. Judge Malone did serve as the chief judge of the Court of Appeals from October of 2012 through January of 2017. We're very honored to have him, and we do thank him for taking time from his busy docket to help us resolve this appeal. With that, Mr. Calvert, you may begin your argument.
Thank you, Your Honor, and may it please the court. Catherine Roll is a 66-year-old mentally and behaviorally disabled lady with an IQ of 51 who's been a patient continuously at Parsons State Hospital and Training Center for over 50 years, since 1970. After all these years, the state of Kansas has decided that it's time to force her out into private care known as community-based services. Before 1970, Catherine lived at home, attended public schools for children with intellectual and developmental disabilities. When she began to exhibit the increasing symptoms of schizophrenia, accompanied by serious behavioral problems and some violent, she was turned over to the care of the state at Parsons State Hospital and Training Center. She remained there with effective active treatment and control for decades, well up to the present day, with conditions clearly of a permanent nature, not subject to cure. She is happy, healthy, and safe there. When Catherine's parents passed away, her two married sisters assumed Catherine's guardianship. In 2016, the state advised them that Catherine would be discharged to community-based services. The guardians were skeptical of private community care for Catherine because of the high quality of care that she received at Parsons. When it became clear that the state intended to push the issue, the guardians found it necessary to engage counsel and file this lawsuit. And in the lawsuit, we've asked the court for an injunction preventing the discharge to community care. State requested a guardian ad litem be appointed, and that request was granted. The state selected the guardian ad litem. All three guardians oppose transfer to community care and think that she ought to remain at Parsons.
Mr.
There
Calver, Mr. Calver, can I clarify something right at the start? The 2016 contact with the Guardians, what fueled or motivated the discharge to community services was based upon financial concerns and a reduction in the budget as opposed to any other factor in terms of needs being met in a lesser restrictive environment or anything like that. The motivation for that phone call or contact was based upon funding.
That's correct. There are three main issues in this case, any one of which give Catherine Roll, through her guardians, of course, the right to stay at Parsons. The U.S. Supreme Court mandate in Olmstead, the Americans with Disabilities Act, and the Social Security Act. The Olmstead issue is applicable by virtue of the clear and unambiguous language of the holding by the United States Supreme Court in Olmstead. Now, Olmstead holds that there are there's a three-pronged test on whether the patient should be discharged from an institutional setting to community-based setting. The first and third are not necessarily applicable because the first is that the treatment professionals determine such placement is appropriate. And the third is that the placement can be reasonably accommodated, taking into account the resources of the state and the needs of others with mental illness. The second is that the affected persons do not oppose such treatment. And in this case, the affected person does oppose such treatment by and through all three of her guardians, the two co-guardians who are her sisters, and the guardian ad litem have opposed a transfer. So the requirement that the affected persons do not oppose such treatment could not be more clear.
How do you respond to basically the Court of Appeals conclusion that the ADA is really an anti-discrimination focus and it does not protect against placement in more restrictive environments, just lesser restrictive environments? Why are they wrong there?
It's the interpretation by the Court of Appeals that is incorrect. The statutory interpretation, and that's actually the second issue, the Americans with Disabilities Act. Kansas law clearly states that the most fundamental rule of statutory construction is that legislative intent governs if it is ascertainable. And then, and the court has said that accordingly, courts need not resort to statutory construction if a statute's language is plain and unambiguous. And that is clear that that's what the law of construction is. So the Olmstead Court cites with approval the ADA regulation, which is virtually identical to the statute, the section found in the Americans with Disabilities Act that I'll call the ADA, when it relates to accommodations and services. When it says that nothing in the chapter shall be construed to require an individual with a disability to accept an accommodation, aid, service, opportunity, or benefit which the individual chooses not to accept. And that just about covers the waterfront when you talk about accommodations, aid, services, opportunities, and benefits. So there's nothing ambiguous at all about that statute. I mean, the meaning is plain as day. She does not want to accept the accommodation, aid, service, opportunity, or benefit of community-based services. And she cannot be required to accept it.
Mr. Calvert, that's really the essence of this whole case, isn't it?
Well,
I mean, you're saying, I mean, yours is to reduce it down. You're saying you have a squatter's right in that bed at Parsons. And as long as you don't want to leave, they can't make you leave, even if you're getting more, you would be getting more services or services in a more restrictive environment at Parsons as opposed to the community. None of those facts matter. The only fact, the only two facts that matter is you are there and you don't want to go.
well, she has to be qualified to stay at Parsons. And she is. So where you're qualified, and that brings the Social Security Act into play, which says essentially that where you're qualified to stay one place or the other, you got to be given a choice of what to do. And that's at 42 USC 1390N, 1396N C2C, where you have the ability to be cared for at Parsons and qualify for that care. Then if they try to transfer you, they can't do that if you're opposed to the transfer. If you choose to receive the care that you're qualified to receive, and that care is at Parsons, you can do that. And actually it's, that's the statute, but it's more clear, I think, in the regulation, which says
How do we get around the district court finding and the Court of Appeals finding that your client really does not have any active treatment needs? I kind of don't understand that finding, but explain to me how it is that we should address that, because that would seem to suggest that she's not qualified to stay at Parsons. But I would agree that it seems that under the SSA and Medicaid, what operates for community care is a waiver. But address the Medicaid issue and the district court's finding and the Court of Appeals affirming that there's no active treatment needs.
The evidence is clear through the state's evidence that she is in active treatment. And the list of all the active treatment issues is found in Exhibit 25, which was a defendant's exhibit, and lists all of the different parts of active treatment that she's in. In addition to that, the witnesses for the state testified that she's in active treatment. And the witnesses being Dr. Ray, who was the former head of Parsons, Karen Van Leeuwen, psychologist Eric Schonecker, psychologist Robin Thomas, Heather Pace and Lori Hinman, who are CDDO representatives, support that. And in addition to that, she is deficient. I think Dr. Ray said that she needed to be deficient in 3 of 4 domains. She's deficient in all 4 domains. And active treatment is certainly justified for that. In fact, she tested on a test called Vineland 2 from age in different areas of life skills. She has the ability of a person aged 2 years and 7 months up to 5 years and 4 months, with a couple of exceptions. So there isn't, I mean, the Court of Appeals called this a difference of opinion, but there wasn't any opinion stated by any of the witnesses that she was not in active treatment.
Mr. Calvert?
Mr. Gilbert, go ahead. Go ahead, Justice Wall.
Okay, thank you, Chief. It almost seems to me that the definition the district court uses for active treatment is whether or not there are sort of extreme behavioral issues that are being manifested. And do you think that comports with the statutory and regulatory definition of active treatment?
Not one
And
single bit,
if not, can you explain why?
because it's not in the statute.
And what is in the statute then?
That she be in active treatment. Period. And the
Right,
state,
right. But what does active treatment mean? What is the legal definition of active treatment? It has a specialized meaning, does it not, under the statutes and regulations?
well, it doesn't, and I don't have, that's in the brief, I think, and I don't have it at hand right now. I sure wish I could answer that. I tried to anticipate all the questions, and I didn't anticipate that one because it's just not part of the law.
I can maybe jump in because the question I was going to ask is if 42 CFR 483.440A is where we look for the definition of active treatment, because it talks about a continuous active treatment program, which includes, and then it goes on to give us a list of types of things, such as training, health services, and other things. Is that the definition that we look to?
I think so, yes.
And given that, my question is, did the Court of Appeals apply the correct standard of review when they look solely for substantial competent evidence to support the district court's finding, or should we apply a mixed standard of review where we not only look for substantial competent evidence, but we also have a legal question of whether that evidence meets this definition?
Well, the Court of Appeals, I don't know, it certainly doesn't support if there is a behavioral issue, or if there are no behavioral issues. That doesn't mean she's not in active treatment. Because Dr. Ray, for example, and I know this is his conclusion, but he knows what active treatment is, and he could have qualified that. None of the witnesses qualified that. They simply said that she's in active treatment, and she remains in active treatment. So I don't know if that answers your question, Judge.
Do you have a position on what our standard of review is? Is it just substantial competent evidence, or do we also look at a mixed question of fact and law?
Well, it's got to be a mixed question because the statute is broad and covers a number of areas. And you can't say that just because she's not in active treatment in one of those areas and is in active treatment in a number of the other areas, that she's simply not in active treatment. That just doesn't make sense. If you go to the statute, she certainly complies with the statute. And the active treatment listed in the brief and in Exhibit 25 certainly qualifies as active treatment. And the main thing is that, I asked Dr. Ray, I said, you're not going to tell the government that she's in active treatment if she's not really in active treatment, are you? Not going to do that just to get the money from the government. And he says, oh no, of course they're not. She's got to be in active treatment as defined by the statute before they can submit the bill to the federal government for her care. And she's clearly in active treatment.
Justice Wall, I may have cut you off by jumping in there, so I want to make sure we can return if you have the other questions.
No, you covered any follow-up I might have had, Chief Justice.
Let me jump in here. I don't think it's any secret that the services that are available for people with developmental disabilities in this state are limited. Your legal position, it seems to me, is that if there's someone else out there who could benefit from the services at Parsons and needs that bed, that your client, regardless of that, your client has the legal right to hold that bed, correct?
If she qualifies to be there, she does.
I understand. I mean, I'm trying to reduce the facts that are required for what you're really asking for. And I accept your correction that one fact is, does she qualify for services? And that's a broad range, but does she qualify? And is she there now? And if she's there now, she's got a right to stay in your view of the law, right?
That's correct. That's correct.
Regardless of anything else, because I'm trying to strip away the factual fight that the parties had below about whether, she could benefit by an HCBS program, all that. None of that matters.
That's correct.
Okay.
Doesn't matter if it's appropriate or inappropriate.
Right. And it doesn't matter. And it doesn't matter whether someone else needs that bed and can't get to it because you're there.
There's always somebody that needs the bed.
I understand that.
And that's right. And the guardians in this case, she has to speak through guardians. If there's any issue about whether she can speak, there's a recording of an interview that is kind of mind-blowing, where she just talks gobbledygook.
Right.
And it makes no sense. And that was in evidence.
How do you guys view the state statutory requirement that one of the obligations of the guardian is to, and I don't have it in front of me, but is to advocate for the least restrictive environment of the individual?
And that's exactly what they believe that they are doing. That's what we think we're doing. She's got a lot of independence at Parsons. In community base, she stays in one house. She's bused to what was called a warehouse of.
I understand that, but what I'm trying to say is, but then that injects a factual argument as to which is the least restrictive environment. And so I'm trying to ask whether the state law adds an element that needs to be considered by the court, or are we still back down to I'm there and I get to stay there as long as I can use the services?
State law does not add that element of the least restrictive environment because that doesn't apply to her situation. Not in this case. Might have if the state had approached this in a different way in a different court, like the probate court, or in the guardianship proceedings. It might have become an issue there, but it's not an issue here. It's just not part of the statutes. It all comes back to the ADA and the Social Security Act and Olmstead, which are all three clear as a bell. The injunction should have been issued, and it should be either remanded to the court, district court, with instructions to issue the injunction, or this court should issue the injunction. So, against transferring her to community-based services. So that's all I have, unless there's some more questions.
I have one quick question, counsel, a clarifying one. I'm trying to understand in my own mind the legal standards that govern. I mean, there's two options. You've got community-based care and hospital care. The Court of Appeals, to me, as I read the opinion at least, says that because the district court concluded community-based treatment was appropriate, that ipso facto, as a matter of logic, means that there was no requirement of hospital care. I presume you disagree with that sort of logical leap.
Yes,
And
totally.
so is there case law or what do you point to in the law to demonstrate that that reasoning by the Court of Appeals is wrong?
Well, because Olmsted injected that one provision in there that says that the patient can only be transferred if they have no opposition to the transfer.
I guess I'm asking something different. The Court of Appeals seemed to suggest that it's impossible for a patient to be qualified for both community-based care and institutionalized care. The Court of Appeals says those two things are mutually exclusive, as I read it.
And the Social Security Act says they're not mutually exclusive. They says they got a choice. The statute says that, the regulation says that, and the Ball case says that.
Refresh my memory. The Parsons State Hospital is actually licensed as an ICFMR. Is that right?
Yes.
And when the state operates under a waiver, they have to, in exchange for that waiver, provide certain assurances in order to participate under that waiver, as I understand it. Is that correct?
That's correct. And one of those assurances incorporates the Social Security Act provisions we're talking about here.
And it's my understanding too that part of the assurances in 441.302 is that in order for an individual to be eligible for community-based services, they have to have care needs that would require ICF level of care, but for those community-based services.
That's correct.
Okay. So regardless of the setting, whether it's in an ICF or community-based services, the level of care is the same based on the regulatory scheme.
Yes.
Or the care needs, I should say.
And that's correct. And it's only the method that differs.
And by virtue of the fact that it's a waiver, either implies or legally is requirement is that it's a waiver that you have to agree to waive. As opposed, I mean, you can waive the waiver, correct?
Waive the waiver. I'm not.
What I'm suggesting is the whole placement outside of the ICF to community care is a waiver provision. Is that right?
Well, the provision of whether Social Security, whether the federal government will pay for it, Social Security Act would not permit that unless the state obtains a waiver that allows the government to pay for it. And in order for the government to pay for it, there have to be numerous provisions in that waiver where the state makes assurances to the federal government. And the assurance at issue here is that if she qualifies for care at Parsons and care at community-based services, that she's got to be first told about that, and second, she has to be given a choice. And there's no interpretation to that. That's clear.
Are there other questions? Thank you, Mr. Calvert.
Thank you, Your
Mr.
Honor.
Chalmers?
May it please the court. This suit was filed in August of 2016. Just days before a deadline that had been placed saying, look, we need to do something on placing Ms. Roll in another environment. She can't remain in the Parson Hospital. And here we are. The reason we're still here is because there was a temporary injunction. And then there is a continuation of that injunction under a supersedious bond, whether appropriate or not. That's where we are. Ms. Roll was selected as an individual who was housed at Parsons, who would be better served in a more integrated environment, getting her out in the community for her benefit. I think, Justin Rosen, that finances were stipulated not to be a factor as in terms of whether it was to the advantage of the state to put her in community placement or otherwise. And I think that where finances were a factor is because it shined a light on saying who is it that could be moved from the community. And that's how I read the findings of the district court as well. In any event, the case was tried in Sedgwick County, which is where plaintiffs filed it, pursuing two federal theories. They didn't seek any sort of relief out in Parsons where the probate court would have been involved. And the factual matter, and in fact, the trial itself was of one issue, and it was the ADA. It was whether or not it was in the best interest to move Ms. Roll into an integrated placement if the guardian's opposition was reasonable. That's how the plaintiffs presented their case, and that's why you get a little bit of disconnect between the evidence and some of the questions that you're addressing in the appeal now that it's worked its way to the Supreme Court. It wasn't until after the trial that this Medicaid freedom of choice claim was made. I know Mr. Calvert refers to it as Social Security Act, and I suppose that's possibly now a subset of the Affordable Care Act, but Medicaid Freedom of Choice Act is typically what it's referenced to. The court, and I think, in all deference to the trial court, didn't quite understand what argument was being presented on the Medicare freedom of choice claim, allowed the amendment, and in defense of the trial court, and then didn't really rule on the argument that's being made today. And in defense of the trial court, that argument has evolved over time. Before you, the argument seems to be, although I'm not quite clear on this, that there is a statutory obligation really in a regulation that would say that there is a choice that needs to be made between hospital level care and the community-based care. The regulation statute doesn't get you there, but that's what the argument has evolved to.
Mr. Chalmers, I want to interrupt because we're going to run out of time, and this is complicated enough that I want to get this boiled down to its core. And when you started out your presentation, you said this whole dispute started when the state of Kansas, the Parsons facility, decided to discharge this woman. What gives the state the right to discharge her out of an ICFMR?
My understanding is the position taken by Dr. Ray is because she doesn't qualify for active treatment needs that are required in the most restrictive environment provided by Parsons.
Okay, and where do we find that legal framework that the question is now getting her service in the least restrictive environment for someone who is already in and qualified for an ICFMR program? That's what I'm having difficulty with.
And I appreciate that.
I really do think this boils down, as much as you guys are fighting about a whole bunch of other stuff, this really boils down to, do you have a right to discharge her? You clearly believe she's entitled to Medicaid services because you're trying to put her in HCBS, and that's the same funding mechanism. But you want to discharge her out of an ICFMR, and what gives you that legal right?
And I appreciate your question, Your Honor, because I think that it gets to the confusion of the issues at the heart. This case was never about whether she should be discharged or not discharged. This case was about whether or not there was a violation of the ADA, which means there has to be discrimination because of her disability, and there isn't. And it's about the Medicaid freedom of choice provision that provides as the predicate, not whether or not she can remain and receive funding at the Parsons Hospital, but rather whether she is, quote, likely to require the level of care provided, and then in the different settings. And so
sorry to interrupt, counsel, but what's your position on that exact question? Whether she's likely to require the level of care provided in a hospital?
Well, she isn't. At least that's what the testimony was that was adopted and by the district court in findings that the Court of Appeals then accepted in its reasoning as to explain why there's no violation of the Medicare waiver freedom of choice provision. Dr. Ray in volume 5.
Can I follow up on
Yes, sir.
that? In looking at the language where the regulation uses that likely to require the level of care, the subsection that is also the choice subsection is embedded within that same subparagraph. And that choice section is written as given the choice of either institutional or home and community-based services. So does it follow from what you have just said that it's the state's position she no longer has a choice of institutional or community-based? It's
Again,
just her choice now is community-based.
Again, very helpful question because it gets to, I think, is an important point. There is a difference between what the Olmstead talking about when it's talking about institutionalization and between what the Medicare waiver provisions are talking about when they're talking about institutional care. The choice is between the same, it's a horizontal choice, a choice between the same level of care provided or is likely to be required to be provided. Remember, what we're talking about in the choice is between when they talk about the institution are those benefits that the state provides that are paid for by Medicare funds to folks with the disability issues. So the choice is between that which the state provides with all the elements that the rules set forward in the Medicare Act as to what they have to do, and those which can be provided as an alternative, same level, through the waiver. The choice is between, first you have to inform them of what the available or feasible alternatives are. Then you have to give them the choice between those two. And probably for me, the easiest way that that's illustrated is looking at a regulation 42 CFR 441302G, which contrasts what is an institutional hospital, nursing care facility, intermediate care facility. There's the argument that I think that council makes, which isn't supported by the statute or the regulation, is that the choice is a vertical choice as between the more integrated setting and the less integrated setting. That's not what that waiver provision is talking about. And that's what the Court of Appeals was talking about when it said, look, what we found here is that you don't have evidence that you as the plaintiff would be required to produce, that you are likely to require the level of care at these services. Now,
And counsel, that gets directly to my concern here, or confusion. Did the district court ever make that fact finding?
Yeah, I mean, they made that finding in the context of, the Court of Appeals set it out, and it
Well,
is.
what the
it
Court
is
of
a-
Appeals, what
it
the
is
Court
a-
of Appeals said, as I read it, is that the district court actually did not make that finding. The Court of Appeals inferred that finding from the district court's conclusion that community-based treatment was appropriate. And this is the same question I asked your opposing counsel. Is that inference, that logical deduction, appropriate or legally defensible?
Yeah,
I'm not-
I think that the district court did, and I'm looking at the Roll decision, quoted from the journal entry, said that given Ms. Roll has no active treatment needs, members of Ms. Roll's treatment team at Parsons Hospital as simply providing supervision to Ms. Roll and can be accomplished in a community-based setting. I think that's what they were focusing on, the facts, which may be a little different than the.
That is different, isn't it? That's different than from whether or not the individual is likely to qualify for hospital level services. That would trigger the Medicaid freedom of choice provision, if that's what we're calling it.
Yeah.
It's not only different. Tell me if you think it's even consistent with the trial court's findings at paragraphs 31 and 32, where the trial court said the treatment professionals are actively provided care and support to Ms. Roll throughout her stay at, or through her stay at Parsons. And then in the 32, they list the psychological services, the medical services, and, 3 lines are basically of the services, the specialized services that are being provided.
Well, I think it is consistent, and I think it gets to the discussion that you had with Mr. Calvert, or I can't remember if it was you, Your Honor, or others, about active treatment. I believe that the Medicare freedom of choice provision is talking about a horizontal level of care. And for instance, Dr. Ray at volume 5, starting at page 159, indicated that in his opinion, she, being Ms. Roll, no longer needed our level of service. At page 172, he said she did not have any active treatment needs that required her to be housed in this most restrictive environment. And I think that one can have active treatment, and yet that active treatment can be provided in a more restrictive or least restrictive environment, which is what Dr. Ray said at page 206, than at Parsons. So it's the level of care and whether or not it is providing what active treatment can be provided at a more integrated environment that is the issue when you're talking about level of care, as opposed to whether or not there's active treatment. And I think that responds to your inquiry, Your Honor, as I remember it. But the choice is between the waiver and between what the state would provide at the same level of care. Under the Medicare provisions, yes, Your Honor.
I'm sorry, I didn't mean to cut you off.
No.
I just didn't want to stray too far from this point. But I understood Mr. Calvert's argument or position to be that the level of care or the care needs is going to be the same, whether it's in a community-based setting or at an ICF, because a beneficiary under Medicaid is not going to be eligible for home-based services if they don't have active care needs that would otherwise require ICF level of care. And that's, how is that not, how is that line of thought not consistent with the state assurances in 42 CFR 441.302?
Well, I think that his argument, and I think the bright white line to look at this is to say whether or not if you qualify for ICF services, Does that mean the same thing as level of care? Now, the statute and the regulation dealing with the waiver use the term level of care. And what the testimony was is that you can have different level of cares within an ICF, within I guess an HCVC or a home care setting. So I think if we're going to look at the Medicare waiver and the freedom of choice provision as the hook to say you can't be placed in a least or more integrated environment, we need to look at the language of the statute and then of the regulation itself that would draw a distinction, I think, between when they use in other statutes, what is a qualifying feature to be in the ICF. I think that
Has there been any difference in the level of care and or the treatment that Ms. Roll is receiving between 2010, 2016, and when you began suggesting that the community-based approach is more appropriate? I don't see any difference in what she requires. Is there any difference?
Well, between 2010 and 2016.
I'm just saying prior to 2016, clearly you had annual reviews, semi-annual reviews that are required to get reimbursement, finding that the placement at Parsons was appropriate, given her level of care and the treatment that was required. And I would say, anyway, it just seems to me that part of what Parsons is doing fits the definition perfectly. It's the prevention or deceleration of regression or loss of current optimal functional needs. That's what's happening. She's at Parsons also. But anyway, is there any difference now than before? It just seems to me that.
Well, the testimony that Dr. Ray provided and others provided is that that there were changes in her conditions after the 46 years she's been there that explain why she it was no longer in her best interest to be at Parsons. That's at volume 5, starting at 184. There was the ombudsman at volume 5, starting at 204, said she can live in the committee very easily now, and gave the reasons for why she doesn't meet our level of care. So I think that was the argument that was made at the trial court level was what are the circumstances now that would suggest that she needs to remain in the hospital? And the district court found quite clearly under that trial theory that she didn't need to remain in the hospital and it would serve her best interest to be removed. There are a couple of other, I know this is much of a segue, but there are a couple of other points that I think are of interest when we talk about the Medicare waiver and the freedom of choice provisions that I think the court may want to think about. One is they never got to the choice part. This lawsuit was filed. There never was never identified what the options were between the various community placement and, I guess, ideally or possibly a placement in an institution not at Parsons that provided those same level of care, which is problematic, I think, to plaintiff's theory. But second, there is an issue of who makes the decision, who makes the choice. The presumption, as I think Justice Biles' suggestion is that plaintiff is arguing, well, that's a decision that's made by the guardians. And that we ignore the fact that the authority of the guardian in the state of Kansas is restricted. You cannot, as I read the statute, put someone in a more restrictive environment if it's appropriate to put them in a more integrated environment. That's our public policy.
Yeah,
So
Mr. Chalmers, I'm struggling and to the point of frustration here, because if somebody thinks these folks ought to be removed as guardians, then there's a way to do that. And this isn't it. this is a fight that the state of Kansas started because it wants to discharge this woman from Parsons State Hospital, which, as I understand, and I guess I want to confirm this, this is, as I did with Mr. Calvert, I want to make sure you guys agree. Parsons is an ICFMR, right? It's licensed as an ICFMR.
I understand that it has that license. I don't know that it doesn't have others. Yeah.
I mean, my memory is that it's considered a large bed ICFMR. So all I want to know is what lets the state, as the operator of a large bed ICFMR, kick this woman out of their program? What's the federal statute, the federal regulation, the state law, the state regulation? Where do I go to look to see what empowers you to discharge her? Because that's going to frame what's relevant for so all this discussion about what she needs, whether the guardians looked at all the right facilities, all of that stuff falls to the wayside once we know what the legal basis is for the state's actions. And I feel like I'm not getting a straight answer.
And I think that there is no straight answer in the record, because that was not how the case was tried or presented. That was not the argument made by the plaintiff on the Disability Act, where they said there's a choice. And that is not the argument that was made on the waiver provision. This is not.
This is your client. What's your explanation for what gives them the legal authority to do what they're trying to do?
Well, I understand Dr. Ray's testimony is because she's not qualified any longer at the hospital.
And where is that in what law are you using? That's what I'm trying to get at.
If you're asking me for what statute that would give them the authority to say, now we're not going to provide these services to you, I can't give that to you. It is not part of this case.
Counsel,
yes, I'm sorry.
can I ask a follow-up to that?
Please.
I understand you're saying the doctors in their medical judgment say this individual doesn't require our level of services. Is that a thing in the law, though? Is there a sort of ships passing in the night between medical opinion and what the law says? Because isn't the answer to Justice Biles's question that the only way the hospital can lawfully discharge is if the individuals no longer qualify for Medicaid services, period? Isn't that the answer? And the legal answer, not necessarily the medical answer.
I can't say that it is. I don't know. I mean, it is not, this case was not presented as we are being denied services because we're being removed from Parsons.
But surely we can come up with some, at least, ideas about what the law says. I mean, is it true that we just don't know what the law is on when the hospital can discharge a client?
I think it's true that I'm not prepared to point you to the direction to help you, and I apologize for that. But that's certainly something that's capable of being answered legally. It just is not part of this case. We are now evolving from the district court to the Court of Appeals to now a new case in the Supreme Court.
But the district court made findings on this issue, right? I mean, they didn't it reach the choice provision by concluding that there was no active treatment needs?
The district court found that the plaintiffs had failed to show that this was the level of care and found evidence that was just the opposite, that this was the level of care that was the choice.
So I'm going to jump in with one more question. It seems to me as though everyone or many folks, especially on the medical side of this, assume that there are two different levels of care. There's the institutionalized level of care and the community-based level of care. And I get that may be true from a practical perspective, but is that a valid legal distinction? In other words, under the applicable statutes, isn't there really just one level of care? Or am I wrong about that?
It's probably that I'm not following the question as well as I should, but let me see if I can't tackle it this way. Under the ADA, the issue, because of the Olmsted decision, is you must find, subject to some defenses, you must find the most integrated environment. So I think of that as kind of a vertical sort of thing. You're at the hospital, least integrated, community care, maybe nursing care. That's the choice. The waiver provision addresses how at the same level of care, what your options are. And that's
Isn't the underlying principle of this entire area of the law that individuals are getting the same level of care, whether they're integrated or not, and all of these laws are meant to pronounce and put into effect a public policy favoring community integration. But that's not the same thing as saying that that's a lower level of care, legally speaking. Show me where I'm wrong in that.
Well, I won't disagree with what you're saying. If, so long as we can reach agreement when they're talking about level of care in the Medicare waiver provisions, we're talking about the care that is supposed to be appropriate for the individual, and that different types of care are provided at different levels, whether it's in a hospital, whether it's in a nursing home, or the like. So what I think you're trying to do is find what is the appropriate Medicare care, presumably with the assistance of the professionals. The Supreme Court says deference to professionals. And then,
Well, as I read CFR 441.302, it says if an individual is qualified for Medicaid services, they get to choose. That's just how I read the language. It says if they're qualified, they get to choose institutional or home and community based.
I'm looking at 411.302D alternatives. When the beneficiary
The freedom of choice provision.
when the beneficiary is determined to be likely to require the level of care provided in and then it lists hospital and in the different alternatives, nursing home, the intermediate care. Then you fit into the horizontal deal at that level of care. I don't agree if your analysis is that they are entitled and are likely to require care at a hospital, that they get to choose, or at a nursing home, that they get to choose a hospital as an option. I think it's a horizontal choice, respectfully. I thank you for your patience and your questions.
Are there other questions? Mr. Kerwick, you reserve 4 minutes for rebuttal.
Yes, Your Honor. May it please the court, Stephen Kerwick for the petitioner. I'll try and be as brief as possible because so much has been covered already, but two subjects raised in the questions by Justice Stegall and Justice Biles, I think merit a little of a perspective answer by our side. What we've really got here, if it comes down, is what a legal scholar once called a conflict of absolutes. The state would take the position that the opinion of their employees, their officials who are hired by them, paid by them, advanced by them, as to this appropriate treatment choice is going to be binding. And I think that's ultimately what the Court of Appeals says. It's a workaround to the Olmsted and the Social Security Act choice, to which Justice Stegall just referred. We think that choice does rest, in fact, under Olmsted, under the ADA, and under the Social Security Act, with the guardians, the court-appointed guardians, who I can't emphasize too highly, are fiduciaries. The state employees are not. These are conflicting interests. These are adversaries. And our position is that, subject to qualification I'll mention in a moment, the choice of the guardians under the federal law is in fact absolutely necessary. Now, Justice Biles, I think, asked a very good jurisprudential question about squatters' rights, was the expression he used, as to whether the guardians on behalf of the disabled person can, in essence, prevent and forego any adverse or any disapproved action by the state officials. I don't think that's necessarily true, and Justice Biles in a subsequent question kind of got onto it. The guardians. I'm sorry.
I think perhaps that developed some sort of echo.
Oh, gee. I don't know. Is it working?
There's
I think Mr. Calvert is mine there.
I'm quiet.
I think your microphone picking up the sound.
Can I try?
there, that did improve it. Thank you.
The guardians serve only by virtue of their appointment to the probate court. They're an instrumentality of it as fiduciaries. If, in fact, and I think this is a proper consideration for the court in its supervisory role, if the guardians are being arbitrary, unreasonable, petty-minded, or simply opposing for the sake of opposition, the state has an opportunity to go to the probate court and challenge their action or even to seek removal. I think Justice Biles mentioned that or alluded to it. So this is not an absolute dead end. On the other hand, what I think the Court of Appeals is saying is once the state hospital officials have made their recommendations or made their evaluation of what is the preferred measure of care, that is preclusive as to the opinions of the guardians. And I think that's a particularly undesirable result when the other subject that has received almost no mention here is we have had one totally neutral player come in, and that was the guardian ad litem appointed by the District Court of Sedgwick County at the suggestion of the state of Kansas's attorney. And he went in, interviewed the ward, found that she was not communicative at all, contrary to what the trial court seemed to want to accept, and also that the guardians, the probate guardian's position in opposing any transfer to community care was reasonable, and that the best decision was to allow her to remain at the Parsons State Hospital and Training Center. And I think that's the correct answer. And the other big fact is this lady has been at Parsons from adolescence to now, dotage, I guess is a word. She's 65 years old. That's a half a century. And there's been, in my view, insufficient consideration at all levels to how shocking that is to move someone from their half a century only home to a new and strange environment. And that certainly supports the lay opinion that my clients, as the guardians, have taken in opposing this change. And at the bottom line of everything, we would ask the court to honor that choice as consistent with the federal law stated in the various authorities we've cited. And other than that, I would be happy to answer any questions.
I'll jump in just real quick. I've asked this question before, but I'm focused on the Court of Appeals sentence that says the district court concluded community-based treatment was appropriate. In other words, Roll does not require institutionalized care. And that the presumption behind that is that community-based care is somehow a lower level of treatment. And my question is that legally correct?
No, I don't think so, Your Honor. Excuse me. I'm sorry, go on. I think I interrupted you.
No, just the follow-up question was, where would we look in the law to find the correct answer to that question?
I'm not sure on that point, Your Honor. I'd probably have to defer to Mr. Calvert, who's much more technically, Mr. Calvert, and what he's already placed in our various briefings and petitions. And I apologize for not being prepared on that.
Are there other questions? Okay, thank you to all counsel for your arguments this morning. I also want to again thank Judge Malone for sitting with us and clarify that he is participating in the court's conferencing of this case. That will lead to the court's decision, which he will also participate in. The court will take this matter under advisement, and we will be in recess